Thank you everybody this morning for joining our webinar. Welcome to the session this morning, which is going to be on post-termination restrictions. Just a quick introduction from myself. My name is Scott Garner. I'm Head of Business Development at Rix & Kay. Brief introduction to the firm for some of you who may not be familiar with Rix & Kay. We're a full service law firm based across Sussex and Kent. We have offices in Brighton and Hove, Uckfield, Sevenoaks and Ashford. We're a full service law firm providing services to businesses, and we have an extensive private client offering as well, working for business owners, private individuals and their families. Before I introduce the panelists this morning, just a quick bit of housekeeping. The session is being recorded, so we will make the session available to everyone after the live event, so you will have the notes. And we will be running a Q&A as well, so live Q&A at the end. To put your questions forward to the panelists, please use the Q&A function at the bottom of the Zoom screen, and we'll pick those up at the end. If we have an abundance of questions and we don't have time to get through all of them today, we will come back to you regardless, one way or another, and probably by email. Okay, let me just introduce you to who you're going to hear from this morning. So Victoria Regan is an employment partner at Rix & Kay, and I'm sure many of you are familiar with Victoria and have worked with her in the past. And we're delighted to be joined by Adam Ohringer this morning. Adam's a barrister at Cloisters Chambers, and he's regularly involved in employment-related litigation in the High Court and represents claimants and defendants in high-value claims for breach of contract and restrictive covenants. So we've got a wealth of experience on show for you this morning. So enough from me. Let's hand over to Victoria, who's going to take you through the first session.
Thanks, Scott. Good morning, everybody, and welcome to this morning's webinar on post-termination restrictions. So just a brief overview of what we'll be looking at, starting to look at the different types of restrictive covenants or post-termination restrictions that there are, and looking at their enforceability. Then taking a look at the legal approach for enforcements and applications for injunctions, and then considering possible alternative protections to those restrictions. And then at the end of the webinar, just take some time just to look at the potential impact that COVID-19 may have had upon existing post-termination restrictions, and also just discuss the recent consultation that's taken place on the reform of non-compete clauses. So post-termination restrictions are typically clauses which prevent and prohibit an employee from competing with an ex-employer for a certain period of time, having left employment, and preventing them from taking customers, clients, information and knowledge gained whilst in employment. So it's vitally important to have express post-termination restrictions in the employment contract to protect the business, customer-client relationships, restricting the use of the information, prohibiting competing, preventing damage to the company, perhaps deterring an employee from joining a competitor, and perhaps deterring a new employer who may also be found to be in breach. So there are different types of restrictive covenants. We've got the non-compete, non-competition clause. So this is really the gold standard, as you like. More difficult to enforce, but if it is, it's actually claimed to be the most powerful weapon in an employer's armory. This essentially is to prevent the employee from competing and joining a competitor or setting up their own rival business. It's not simply for preventing competition outright. When looking to the possible reasons or the justification for having a non-compete clause, it might be that the confidential information that employee has is so integral to the business that it would be incredibly damaging if used. It also might be more appropriate if the employee is senior, or indeed if your business is highly specialized or niche. For non-solicitation clauses, essentially this is to prevent the direct contact from the employee to your customers and clients with a view to obtaining business. They can inform that they're leaving or where they're going, but there is a fine line between acceptable communication and unlawful solicitation. So taking it further from saying they're leaving, where they're going, and then with an invitation to contact me and I can carry on assisting you, that tilts the balance. So these clauses are limited generally to the customers and clients with whom that individual has dealt with. There will also be what we call like a look back, a backstop period in there, limiting the time. So where we'll have a prevention of contacting clients and customers with whom the employee has dealt in the last 12 months leading up to the termination of their employment. Sometimes there are issues where the employees have their own following and they allege that, well, actually, these are my own contacts, they should be excluded and they're exempt from non-solicitation clauses. Well, quite frankly, unless they are specifically carved out at the outset and agreed in the contract, this will not be implied. With non-dealing clauses, so restrictions of contacting with clients and customers can be extended to cover situations where the employee does not actively entice, but in fact, where those customers and clients make the first point of contact, they contact the employee first. And in this situation with the non-dealing clause in place, the employee must still say they cannot work for them. This, as I say, there's an absence of employee solicitation, that does not matter, but these clauses are more likely to be enforceable if you can prove that there is a close personal relationship between that employee and that customer. And if this clause is not enforced, it could expose the business to significant risk. The non-poaching clauses, these essentially are to prevent former employees trying to solicit or poach your teams, your staff. The reason being why this is necessary is to maintain the stability of your workforce. It's important to think about which employees will be within this clause. It can't exclude them from all employees within the business, but perhaps maybe excluding taking staff of a more senior or expert level and those with whom the particular individual worked with. We're also seeing an increase in team recruitment and poaching. So there is an increased trend at the moment where clients are asking if we can try and limit team moves. So stopping that employee from moving as a group all at once, which again could be particularly damaging. So what we're putting in place at the moment is what we call waiting room or departure lounge clauses, which essentially requires the employee to physically sit for 6 months before they are in a position to be able to then go and join their former employees. So arguably, this may be deemed a little bit overly restrictive, but it could serve as a good deterrent at the very least. Geographical restrictions, I'm sure many of you will be aware of these. So they basically prevent an employee from carrying out activities within a certain radius. A radius, obviously, the larger the area, the more difficult it is to enforce. And also, realistically, these are becoming less common, less enforceable, and even more so, given with lockdown and home working, it shows that we really do not need a physical presence. We're less reliant on that and more on electronic communications. But that said, there are certain businesses where it could still be appropriate, such as hairdressers who really do rely on local goodwill. But it would not be appropriate to have a geographical restriction, for instance, where businesses are associated with a particular area. So say, for instance, financial services in the City of London may not be able to restrict an employee from operating in that area because effectively you will be preventing them from working, and as such that could be deemed a restraint of trade and therefore unenforceable. So when looking at whether you do wish to have any form of geographical restriction, do take time to consider whether there is an actual relationship between the interests that you're trying to protect and any specific geographical area. Look at the area where you're doing activities. If you're only working within, say, London, is it really necessary to have a geographical restriction which extends the whole of the UK? Look at the size and the nature and the density of the population of the area. The more dense the area, the less likely it is to be enforceable. And think about the duration that you're going to apply the post-termination restrictions. This is really important. All covenants will be limited in time, but really think about how long it will take for you to find a replacement for them to settle in and then to forge those relationships with your customers and clients. Think about if there's a particular shelf life in respect of confidential information. Think about the frequency of contact that the individual has with contacts and customers and clients. Is it regular? Or maybe it's only on an annual basis, such as insurance renewal policies. In such instances, it may therefore be more appropriate and enforceable to have a 12-month restricted covenant. Think about staff turnover and notice periods. If you've got high staff turnover, short notice periods, it's going to be very difficult when trying to enforce a non-poaching restrictive covenant about the stability of the workforce. And as Adam will be talking about later, it's really important that they do not go and they're not longer than is necessary to protect the particular legitimate business interest. But when discussing with clients, look at maybe having different timeframes for different covenants. Is it really necessary to have, say, a 12-month non-compete and a 12-month non-solicitation and a 12-month non-poach? If you've actually got a non-solicitation clause in place, you might have a reduced non-compete clause, a further reduced non-dealing, and a further reduced non-poaching clause. Really just to apply minds as to what would be deemed reasonable in the situation. And I also do suggest that when you're applying your mind, and then just to take note of the rationale as to why it was necessary to apply those time periods for those particular restrictions in respect of that particular individual, and then keep that note on file. Just to also show that it's not just a blanket approach and it's not just one size that fits all. And lastly, just some key considerations in respect of post-termination restrictions. It's really important to note that the covenants are judged on the time that they are entered into the contract. So for instance, this is really important that if an employee has a changed job role or if there's a promotion, it's really important to keep updated and to revise covenants so that they are applicable to that particular role. It's also important to be aware that if the covenant is unreasonable at the time that they were entered into, this will still not be saved by a promotion later on, even if that does seem to be reasonable at the time of termination. We're asserting clause about the reduction of covenants during garden leave. So essentially, if somebody has a 6-month restriction and they're placed on garden leave for 3 months, then there will only be 3 months left effectively of that post-termination restriction to run. This actually potentially makes it more enforceable. It's really important just to be mindful that in the event of an employer's fundamental breach or constructive dismissal situations, the post-termination restrictions fall away. So in the ordinary principles of contract law, if the employer breaches or fundamentally breaches that contract, so without giving notice, then you will not be able to rely on those post-termination restrictions. And equally, if an employee resigns in response to a fundamental breach of the employer, claims constructive dismissal and is successful, they're able to treat themselves as being dismissed, and as such, post-termination restrictions will fall away. If you are intending to introduce restrictive covenants later on in the relationship rather than at the outset, do make sure that there is some form of consideration payment made at that time, and crucially, do make sure that it is signed and returned. And now I'll pass you over to Adam.
Thank you very much, Vicky. So Vicky's been looking at the post-termination restrictions that you have in contracts as part of business planning. I'm just going to bring my slides up. There we are. And I'm going to be looking at these restrictions from a slightly different angle. I'm looking at the situation where you are, as a business, seeking to enforce these restrictions in your employees' contracts, or as often happens, you have taken on an employee, or you're about to take on an employee who has restrictions in their contract from their previous employment. So I'll be looking at how this works in practice. Now, as you've probably gathered from Vicky's talk, restrictions are extremely powerful. They can effectively prevent an individual from working in their chosen profession. And sometimes it can prevent them from working for a considerable period of time without any pay. So the restrictions are a huge infringement of one's liberty and open to abuse. As a result of this, the courts have set up various rules to ensure that the covenants are only enforceable and can only be relied on when absolutely necessary. The starting point in all of these cases is that covenants will not be enforceable. That is the presumption that the courts come to in all of these cases. But you can convince the court that in this specific case, or in any specific case, the clauses are enforceable and do need to be enforced. But the issue turns on whether the clauses are reasonably necessary, or more precisely, as Vicky pointed out, were reasonably necessary at the time that the contract was entered. And it's got to be reasonably necessary to protect the business's proprietary interests. And we'll look at what that means in a moment. But it's not, the restrictive covenants aren't there to protect the business from fair competition. Restrictive covenants are there to protect businesses from what is properly considered the business's own property. This law is not new. It's been around for at least 200 years in some form or another. And as we'll hear shortly, the law is ripe for review. But this is the situation that we are currently working with. Now, when considering whether a covenant is enforceable, there is a three-stage test. The first part of the test is to look at the covenant and actually determine what the covenant means. What conduct does the covenant restrict? Then one looks to see whether the conduct and the restriction is properly protecting a legitimate business interest, which requires protection. Then thirdly, one looks to see whether the restriction goes no further than necessary to protect that interest. And so if I can perhaps demonstrate this through an example, a classic case in which you have restrictive covenants is in the contracts of estate agents. Now, estate agents, at least traditionally, would be based within a particular town. They may have a set of contacts. They may have goodwill in the local area, and they may be known because of their location on the high street. Now, let's assume you have an estate agent who has a contract restricting them from setting up another estate agent for a period of 12 months after their departure within a 10-mile radius. So we'll apply the three-stage test to that. Now, the covenant can be readily understood. Covenant prevents, restricts the employee from setting up an estate agent within 10 miles for 12 months. We can probably work out what that means. What is the legitimate interest? That's the next part of the test. Now, the estate agent has a list of contacts, a list of customers with which it has a business relationship. It has goodwill in the local area. But here one needs to consider, what is the local area? So a estate agent in a small town may consider that town to be the local area. But in a dense urban conurbation, an estate agent's patch might be a lot smaller. It might just be a neighborhood. Now, if in this case, the estate agent's patch is really within a small town, maybe of a radius of 3 or 4 miles, then their legitimate interest is to protect their goodwill within that area. If the restriction covers a 10-mile radius, as in the example given, then that would be unnecessarily wide. And in those circumstances, the restriction being disproportionate would not be enforceable. So if this were to go to court, a judge would say, your restriction is too broad, unnecessarily wide, and therefore not enforceable. And importantly, there isn't a possibility for a judge to say, I will enforce this only in part. Either the clause is enforceable or it's not. It can't be reduced in scale. Now, legitimate interests often fall into one of these 3 categories, but there are other types of legitimate interests which are protected as well. For example, goodwill in a local area. Now, I did a case a few years ago involving, perhaps slightly improbably, a beauty salon on a high street in a small town. The beauty salon had client relationships, which were properly its property. It had goodwill, having been in a prominent position on the high street for many years, and it also had a pool of employees, which was part of its offering to its customers. And those employees themselves had nurtured and developed client relationships. So all of those aspects of the business were properly considered legitimate property interests, which could be protected by restrictive covenants. In that case that I did, where one employee, in fact 2 employees, went off and set up a rival business literally around the corner, they were prevented from doing so by an injunction in the High Court, because they were taking clients, taking goodwill, and it looked likely that they were trying to also take other employees with them. But again, the courts are cautious about enforcing restrictive covenants. They really do show a lot of hesitation because they don't want to be used in a way which is simply closing down and pouring cold water on legitimate, fair competition. Now, I'm not always keen on putting quotes from cases up on slides in talks like this, but I think this quote is really very important because it really tells you everything about the purpose of a restrictive covenant and when a restrictive covenant is likely to be enforceable. Now, you might have gathered that there are some real difficulties in enforcing restrictive covenants, and it's a high stakes enterprise going to the courts to get an order to have them enforced. But there are often other routes which need to be considered alongside the restrictions, and many of those routes and types of protection which businesses have or can have will provide an easier form of redress if an employee is doing something they really ought not to be doing. So where you have an employee who is taking the client list home or using the client list to set up their own business, that in most cases would be a breach of the duty of confidentiality. And that duty can be enforced much more easily. If an employee is using his position within his employer's business as an opportunity to make connections so that he can start his own rival business, then in most cases, that's going to be a breach of the employee's fiduciary duties or his duties of fidelity to his existing employer. Again, that might be an easier route to stop that behavior. If an employee steals company data, then there are many remedies for all sorts, depending on the type of data which has been taken, which can be used to get that data back and to obtain various promises and undertakings that any data that has been taken has been deleted. And then you also have garden leave clauses. And I think Vicky's going to perhaps talk about that a little bit more, but garden leave clauses are really very powerful protections which businesses can introduce into their contracts. And garden leave clauses, importantly, are much more likely to be enforceable than restrictive covenants. So a garden leave clause simply says that if somebody is leaving the business, either because they are resigning or because their employment is being terminated by the business, they can be required to serve out their notice period at home and not do any work during that notice period, not come into work during that period, and indeed be largely disconnected or entirely disconnected from the business during that period. And you can have a garden leave clause which lasts 6 months or 9 months, where the employee who is departing the business is put in isolation, as it were, for that period. And so they are prevented through that process from taking things from the business with them to their new employer. Garden leave clauses are much more readily enforceable because although the employee is deprived of work during that period, they are paid. They still earn a wage. And so if it goes to court, the judge will look at them and say, with a shrug of the shoulders perhaps, what are you complaining about? You're being paid to sit in your garden. Now, when it comes to a fight over restrictive covenants, there are really 3 parts or 3 stages of the dispute. The first, part 1, is angry letters, often between solicitors. Part 2 is the commencement of legal proceedings and applications for interim injunctions. And then part 3 is the full court case. Now, very few cases get all the way to part 3, but let's look at it in stages. Part 1 is where you have the angry correspondence between the parties and often between the parties' solicitors, where the employer or ex-employer warns the employee that they are bound by the restrictions and that a very dim view will be taken if they breach those restrictions. Now, often this part of the proceedings results in what's called written undertakings. That is a written confirmation by the employee subject to the restrictions that they will comply with those restrictions. Now, although they're called undertakings, they really aren't of any particular legal value, other than the fact that if someone does give a written promise that they will comply with the restrictions and then they breach that promise, they will lose all credibility if the matter goes further. Now, if the dispute can't be resolved through correspondence and written undertakings, it'll move on to stage 2. And at this stage, proceedings are commenced, usually in the High Court. At this stage, the parties can give undertakings to the court. So the employee can say, fair enough, I agree I'm bound by the restrictions. I'll give an undertaking to the court, promising that I'll comply with those restrictions. Now, importantly, an undertaking to the court, in contrast to an undertaking in correspondence, is of the same effect as a court order. That is to say that if someone gives an undertaking and then breaches that undertaking, they might be in contempt of court. If it can't be resolved through undertakings, then normally the claim will proceed to an interim injunction hearing. That means that the parties will say, we've started proceedings, we can't wait a year or so for the case to be heard in full, because all the damage will have been done by then. What we need is an emergency interim injunction to enforce the covenants, enforce the restrictions for the time being. And the court will make those interim injunctions if it looks as if the restrictions are enforceable. And bearing in mind that it might take many months or years until the full dispute gets to court, until the matter gets to a final hearing, the interim injunction will, in almost all cases, conclude the dispute. But if it doesn't conclude the dispute, the parties will move on to part 3, and that is a trial of the case. And that is a full High Court trial where the judge will decide whether the restrictions relied on are enforceable, whether they have been breached. The judge can make a final injunction, although by this stage, the restrictions may well have already expired or be about to expire. And the judge can award damages if it can be proven that the employer or the ex-employer has suffered a loss as a result of the breach by the employee. It's very difficult to prove these types of losses, but at least theoretically, if not in practice, damages for breach can be awarded in addition to the injunction. But almost as important as all of that, if not more important, is the question of costs, because these cases are extremely expensive. And sometimes the cases are taken to the very, very bitter end, only so that a party can prove that it was right, and so that it can recover its legal costs from all the stages leading up to the final hearing. Now, as I said, in terms of the legal proceedings, the application for an interim injunction is the most important stage in practice, because this is really where the business either receives protection from the court or it doesn't. If it doesn't get an interim injunction, then the damage will be done by the time the case actually gets to a final hearing. And so it's very important when at this stage to do things properly. You only have one chance. The court will expect the parties to act quickly without delay. If you believe that an employee has breached a restriction in their contract, but then you wait 6 weeks before going to court, the judge will look at you and say, why did you wait this long? Clearly, it's not as important to you as you're making it out. That would be a reason not to order an interim injunction. it's important to have all the evidence lined up at this stage. That's evidence to show that the restriction, the covenant, was necessary and is therefore enforceable. That's evidence about how the business operates, what type of customers it has, evidence about the sector within it, which it operates. And you also have to have evidence to show that the employee is either in breach of the covenant or is very likely to be breaching the covenant imminently. Because without having all of this set up properly, the judge is unlikely to take the rather drastic step of enforcing the covenant with a interim injunction, and thereby preventing an individual from earning a living. These cases, as I say, go to the High Court. High Court cases, like all legal cases, are serious affairs. The stakes are high. The cases are very hard fought. And the truth of the matter is that many employers, after all the saber rattling in correspondence, will back down before the proceedings get to this stage, because the calculus is quite different when one gets to court. The costs can be significant. Costs can escalate very rapidly. And there is a great deal of uncertainty about the way a court will adjudicate on any given case. So the most salutary lesson of all is that you should only go to court to enforce a restrictive covenant if you are on strong ground and if the issue is really important for you. Having said that, restrictive covenants and their enforcement is open to abuse. And this might be a particularly important point to bear in mind when you're taking on employees and you receive perhaps a letter from their ex-employer saying that they're bound by covenants preventing them from joining your company. Now, one often sees restrictions in contracts for very junior members of staff. That is very unlikely to be enforceable. Junior members of staff generally don't have their hands on what is considered the business's proprietary interests. There are exceptions, but when the receptionist has the same restrictive covenant in her contract as the chief executive, you can be pretty sure that it's not going to be enforceable. You do have cases where employers make empty threats to enforce covenants. Sometimes they just do that to try and scare the employee. Or sometimes they do that to show that they are serious about protecting their business and to deter other employees from leaving and moving to competitors. So be aware of that. Just because you get a threatening solicitor's letter doesn't mean that the covenant is enforceable. It doesn't really mean that the covenant is going to be enforced either. And the reason sometimes that you get these threatening letters about restrictions is that employers sometimes just want to use the threat of legal proceedings as an extension of their own ego. It happens a lot, happens particularly in this area of law. And sometimes they're so outraged that someone has left their business after everything that they've done for them, that they want to hurt them. Sometimes they're so outraged that a competitor has taken that employee on or is about to, that they want to hurt the competitor. And very frequently, they just use this as an opportunity to try and stifle competition. And so if you are faced with a situation in which you might want to enforce restrictive covenant, or where a restrictive covenant is being enforced against you or one of your new recruits, it's really very important to take legal advice at an early stage. Vicky and I both have experience of businesses coming to us having attempted to deal with these situations in-house without maybe a legal footing. And often things can go off in the wrong direction. So getting legal advice at an early stage is very important. And that both gives you important legal opinion about whether the covenant or the restriction is enforceable, but also hopefully gives you the benefit of a fresh pair of eyes, where we can tell you whether or help you reflect on whether this is a dispute worth fighting, or a dispute which can be allowed to fizzle out. And finally, legal advice can also assist you in considering the alternative protections. I've already touched on garden leave, and I've already touched on confidential information, because often the fights over the restrictive covenants are a distraction from the main point, which is whether the employee has taken confidential information with them, on whether the employee can be put on garden leave to create a buffer between employment with one business and their new business they're going to. So that concludes my talk. I think I might have gone slightly over time. Sorry, everyone. Vicky is now going to tell us about how these restrictions are operating in the current pandemic situation, and also how this area of law is likely to be reformed in the near future. As I say, this is an area of law which has developed since Georgian times, and many of the principles I've spoken about are literally 200 years old. They don't apply very easily in the modern economy and the modern world of work, so they are ripe for reform. Over to you, Vicky.
Thank you, Adam. So, as Adam said, we're just going to spend this end of the webinar just to look at the potential impacts that COVID-19 has had upon post-termination restrictions. So what we are seeing is an increasing amount of requests from employees who have been made redundant, asking for their post-termination restrictions to be waived. So it's really a question, it's a decision for the employer. What they may do in these situations is to consider the relevance of the covenants in place at the moment, consider whether they may agree to any reduction in the time limits, or indeed to consider whether they wish to waive the covenants and waive them in entirety in order to assist the employee in finding alternative employment as swiftly as possible. If that's not acceptable, then perhaps there could be a middle ground. It's worth bearing in mind that if you've got a non-solicitation clause, a non-dealing clause, a robust confidentiality clause, then you may be inclined to agree to a removal of the non-compete and a waiver of the non-compete clause. Another angle to consider is if you're in the middle of settling and negotiating a settlement agreement, then you may consider waiving or agreeing to waive certain restrictions and reducing the compensation on offer at the time. Just a thought on furlough and these look-back backstop periods. Obviously, if this clause would normally, with the look-back, we're saying preventing them from dealing with clients and customers with whom they've dealt in the last 6 months. Well, if somebody's been on furlough, it might be likely that they haven't had any activity or any dealings with those particular clients and contacts, and therefore they're not included, they're not caught. So again, if you are dealing with settlement agreements and negotiations at that stage, you might wish to consider inserting a new period, a lengthier look-back period. Another potential area for issues to arise could be where employees may be refusing to return to work as a result of COVID. Whilst there could be a potential for employees potentially to exploit this level of argument, but equally, just to bear in mind that if the employer requires that employee to return to work and failing to deal with any concerns or any health and safety issues, potentially that employee could resign in response to that breach, could be successful in claiming constructive dismissal, and as a result, all of the post-termination restrictions may fall away. So just as a step to protect your business and try to avoid this situation, make sure you've got a COVID secure workplace, make sure you undertake risk assessments, consult with the employee about their concerns to see if there are any justifiable, legitimate concerns, and to see if you can discuss that in more detail and deal with. Home working as well, this may well have an impact on post-termination restrictions. There's obviously been a reduced level of scrutiny that employers can have to see what employers who they are contacting, what they're doing, what they're accessing. So it's a lot more difficult when people are working from home. It's worth considering just reviewing whether people are using their personal devices for work purposes, if that's really necessary, if there's any form of monitoring, how that could be monitored. Increase your security measures of accessing confidential information, and also subject to legal limits, of course, just to see and check your data protection policy to ensure that your policy allows you to be able to inspect systems, devices, if there's any suspected unlawful activity. And lastly, just to look at this consultation that's just taken place, as Adam mentioned. Previously, there was a review in 2016, and it was found that post-termination restrictions were working well, everything was fine. But in December of last year, UK government launched this consultation looking at the potential reform of non-compete clauses, somewhat radical and perhaps worrying for businesses. The rationale for this was that it was to try to balance out the negative effects on the economy and unemployment as a result of COVID, but also to try to unleash innovation and increase competition. There are two main proposals being put forward. So the first, and perhaps if any, might be the most likely outcome, is having some form of mandatory compensation. So in this, it would mean that non-compete clauses will be unenforceable unless the employer pays for that period of restriction. There are no figures in place at present, but the proposal is it will be a percentage of a weekly wage, perhaps 60 to 100%. This is actually adopted in France, Germany, and Italy already. There are also two complementary measures associated with this. The requirement for transparency. So the employer must disclose this clause at the start of employment with the employee. And also there must be a maximum period of time that this can actually last. Again, nothing is set in stone, but the proposal could be anywhere between 3 to 12 months. Obviously, the lengthier the restriction, the more expensive it will be for the employer who has to pay for the duration. And then perhaps the more radical approach, the second approach, is a complete outright ban on non-compete clauses. So all unenforceable, which is actually adopted in California at the moment. So the consultation ended on the 26th of February. So really just watch this space. Government will need time to look at all the responses and then respond and then find time to make any changes. But equally, it could have a significant impact if this is taken forward and could really fundamentally change the way in which businesses can actually protect their legitimate business interests and to try to stop competition. So for this reason, really, in the interim, employers really should think about future proofing, just to see, looking at all their other protections that they have in place, in addition to their existing non-compete clause. So have a review of policies, have a review of the contractual protections that you have a very robust and specific confidential information clause, have clauses about the return of company property, documentation, etc. Have clauses about the deletion of business contacts and from devices and lists. As Adam's touched on, garden leave provision, have that in your contract, because effectively you can then be freezing the systems, keeping them out of the market, and also reducing their ability to be able to compete. And as mentioned, do review your IT security, check backup systems, and also review your policies on monitoring, and again, subject to legal limits, just so that you can inform employees that you will be monitoring systems and emails, and also the reasons for it. Thank you very much for listening.
Okay, thanks, Victoria and Adam, for a really interesting session there. We have had a few questions in, so I'm just going to fill those out to you and we can pick those up. We're aiming, just for everyone on the call, we're aiming to finish at 11 o'clock. We will try and wrap up. If it runs on a little bit, we'll pick up some of the other questions separately and after the session directly with you. So just the first one that came in actually was, and I know Vicky mentioned it during her presentation, was around financial services. And it's just whether any of the panelists, Victoria or Adam, have experience here in terms of the ability to trade and client contact within financial services. Does any of you want to pick up that point?
Vicky?
Sorry, open the screen up. So really just the covenants and financial services, and may have picked it up as part of the talk already, and really it's just to see about the reasonableness of those restrictions and what you're trying to protect and where that particular individual works. So as we mentioned, if they're in a particular area, high dense area, City of London, it might be more tricky to enforce. But equally, if it's more about the level of contact that you have and how regularly you do speak to that individual, if it is on a more annual basis, for instance, then you might obviously be able to justify having lengthier covenants.
It also depends very much on what area of the financial sector you're in. There's a whole raft of cases involving investment houses in successfully enforcing covenants, where they were trading in a very niche area, dealing with very niche types of investments, where contacts and sort of being integrated into that world of business was extremely important. So if you're trading, if you're in the financial sector and you're trading a very niche product, then that is also often a reason why a restriction will be enforceable.
Okay, great. Thank you very much. We've got two more questions I'm going to pick up very quickly, I think. We've got one around people signing restrictive covenants and gardening leave covenants, and whether or not all staff in the business would be required to sign one. And can you also ensure if a member of staff signs anything on departure to impose restrictions, or is this too late?
just to start with that one then, in order to place anybody on gardening leave, it is essential that it is incorporated within the contract, else you wouldn't actually be able to enforce that. So it's definitely something that you need to have as a particular clause. You might decide it's not appropriate, you might not want it for more junior contracts, but definitely probably use more so for the more senior employees. And as far as, just to pick up the question about, is it too late to try to get covenants on departure? Again, if you are in the middle of perhaps settlement negotiations on termination, as part of the settlement agreement, in the absence of any current restrictive covenants in the contract, it could be possible to then insert additional restrictive covenants as part of that deal, because they're getting some form of consideration as part of that package. They may be able to insert covenants at that stage.
In a sense, there's a connection between the two questions, or two parts of the question, because what one normally sees is that the covenants are introduced as somebody goes up the hierarchy in the business, and the covenants get more restrictive as one gets closer to the top, because the covenants are supposed to reflect how close that employee is to the heart of the business, as it were. So the restrictive covenants have to be tailored depending on the seniority of the position, the type of position one's considering. And what normally happens, therefore, is as someone is promoted through a company, each successive contract will have further restrictions, and that's normally how they're introduced.
Great. Okay, thank you. We've got just a couple of minutes, so I want to whiz through these quite quickly. There's one around franchises, actually, and do the same principles apply in restrictive covenants between franchisee and franchisor? Can we pick that one up quickly?
Well, yes, they do. In fact, some of the Georgian cases that I was sort of referring to involve contracts between businesses. And so these principles apply in pretty much the same way to a franchise contract, except that the principles are likely to be applied in the knowledge that the contract was between two businesses rather than the business and employee. And therefore, if two businesses have agreed that there should be a restriction, it's more likely than not that the restriction will be upheld.
Great, thank you very much. I hope that answers that point. I think this one was picked up briefly in the presentations. It's around, obviously, the new way of working, people not being restricted so much by geographical restrictions, use of teams, etc. Are restrictive covenants more difficult to enforce?
I think it's also a question of, again, looking at the time at which they're entered into, etc., and they may have been reasonable at the time. And as the question quite rightly points out, that it's becoming less and less important as to where we're based. And with electronic communications, it's actually, I think, probably more so, say, for instance, that to try to justify a geographical restriction or the like is more difficult, tricky to try to enforce that one. Adam, any comment?
Yeah, it's not just a matter of electronic communications and remote working. It's also the fact that if you're a bicycle shop or whatever, you're no longer limited to trading in your local area. You can be a bicycle shop with a warehouse in Stevenage selling all over Britain, or all over Europe, or all over the world. So all of the restrictions need to be seen and often reviewed in light of new patterns of doing business, and as well as new patterns of working.
Great, thank you very much. We've got one more. I'm going to squeeze this one very quickly, and then we'll wrap up. And I think this one is around gardening leave and whether or not it's permissible to take on a pro bono assignment whilst on gardening leave. in the same industry indeed as well. I suppose there's some considerations there.
Vicky, do you?
I just having a quick assignment.
I think the short answer is that whilst you're on garden leave, you're in the same position as if you're employed in a regular way by your employer. So it depends on your role, depends on how senior you are. But if you're doing some work for a local conservation charity in the weekend, and that doesn't interfere in any way with your employment, then you can do that work whether you're an active employee or whether you're an employee on garden leave.
And also, just in addition to that, it's just to have a look at what's in your contract. So the contract may actually preclude you from doing any form of work, or there may be instances which are expressly carved out that say you can do X, Y, and Z, or with employer's consent.
But there's often a sort of realistic answer to this question, which is if your employer wouldn't have any reason to object, then probably if the working relationship is still relatively sound, the best thing to do is simply to say, I'm planning on doing this. Is that okay? Or can you, just get some sort of confirmation that they're not going to object to it, and make it sound like they're being unreasonable if they do object.
That's brilliant. Victoria, Adam, thank you very much. I hope everyone on the call this morning has taken a lot out of that. We will, as I said at the start, circulate a recording of the session, so you'll have Adam's and Victoria's details. If you do have any further questions or need to pick up anything directly with them, then I know they're both happy to take take your questions. So do drop them an email. We hope you've enjoyed it all. Thank you very much for joining us, and we'll see you all again soon. Thank you very much.
Thank you.